I'm Elena. I am TLS's advocacy officer. I'm based in Brussels. Many of you already know me. Thank you so much for joining this meeting with Indian human rights defenders. Some practicalities first is that, as you may notice, there are two types of audiences in this meeting. There are some who are joining as a meeting with their cameras on, and then some are behind the screen in a webinar. And this is simply because there are quite a lot of you, and we saw this as a way of just managing it logistically. So if anybody would like to speak who currently does not have their video on, raise your hand, let me know. I'll manually turn it on for you. Similarly, this meeting is being live streamed, and it's also being recorded. And this has to do with our pledge to transparency, and also because some people wanted to listen in who are not able to join today. If you're not okay with featuring in the live stream, then we recommend that you turn off your camera and your microphone. The reason that we're meeting here today is to talk about the UAPA, the Unlawful Activities Prevention Act. And India's human rights record was recently under review at the United Nations, and the UAPA came up repeatedly. For example, Estonia called on India to carefully review the UAPA, and Belgium called on India to repeal the law. And this is just the most recent concern. A few months ago, 21 MEPs from across parties wrote to the Indian government condemning the UAPA, and the UN Office of the High Commissioner on Human Rights also criticized the Indian government for using the UAPA as a means of coercion against civil society. So this has been a law that's been quite a lot in the limelight, and yet India recently hosted the UN Security Council's Delhi Declaration, which calls for zero tolerance on terrorism, and the EU and India are really closely engaging strategically on counterterrorism as well. So in light of this widespread condemnation of India's primary counterterrorism law, the EU must be careful and make sure to understand exactly the situation that is ongoing in the country. So to talk about this a bit more, we will be joined by four very strong human rights defenders. We're currently in India, where it's already almost nighttime, so very grateful for this. What we'll do is that I'll introduce each before they speak. They'll speak for a few minutes, and then afterwards we'll have a bit more of a free conversation. And we'll start with Avinash Kumar. He is the former head of Amnesty International India, which was forced to close its operations by the Indian government. And Avinash is now an honorary fellow at the Center for Equity Studies. Avinash, can you tell us a little bit about the history of India's anti-terror laws, and especially how the UAPA has now turned into one of the main tools to quell dissent? You have about 10 minutes or 7 minutes, let's put it at that.
Thanks so much, Alina, for inviting me, and thank you so much, everyone, for actually being part of this very critical conversation. And I have three very illustrious people waiting in the queue after me, and who are far more engaged with in their respective areas, locations, as well as broadly with UAPA itself, currently in India across. So I would leave the larger and nitty-gritties of specific context and the legal challenges, but not just legal, but actually political challenges, which UAPA has thrown, not just for what it is meant to do, but actually for going far beyond its remit in that sense. So I will leave that, but what I'll try and do is I'll just talk about 3 or 4 broad points. One, of course, looking at the historical legacy of anti-terror laws in India, and starting in after the independence and partition of India, what is called starting from PDA, Preventive Detection Act, and then you have MISA, which came in 1971, and so on, and till now, and UAPA. So there's a series of set of laws, and what do they do to us? So one of the things, of course, is that how do we see state perceiving it's a question of security through these laws as part of its larger remit in terms of integration of the country vis-a-vis what it turns out actually in practice across the board, especially targeting a certain population, certain sections of the population. in India and across India. So that's one part very quickly. The second, of course, is also looking at some of the similarities and continuities in these especially around detention and persecution rather than prosecution and conviction. And which you see actually on which, of course, I'm sure people like Suresh and Lara, they all will talk in more detail about it. But the fact that currently in 2020, you have a data and that where they say that out of 5,922 people arrested under the law between 2016 and 19, just 132 people, roughly 2% of the total arrests were convicted, and so on and so forth. And this is incidentally not a standalone example in UAPA alone, but there's an entire legacy and history of that as well through the previous laws. One of the other things, of course, is also to see what it does to minorities, what it does to specific sections of the population. I was talking about religious minorities, Dalits, Adivasis, intellectuals, and so on. So you have a whole range of actually, and once again, continuing legacy across this. In November 2021, Tripura police, one of the states in northeast of India, police booked over 100 people actually under this UAPA simply for actually posting some statements on Facebook and social media and so on. And how that legacy itself also continues to be built from the previous laws and so on. You also have two kinds of tensions emerging within these sets of laws. So, for example, you have at institutional level, you see police, because many of these laws give not just remit to the central agencies and central government, but also to state agencies. So how police uses it across the spectrum, across the country with impunity. So while in certain states, which are so-called hotspot states like Kashmir and Punjab and Manipur, which were around which many of the specific anti-terror laws came, in the name of saving the integrity of the country, you have one set of targets there, but you actually see the remits going much beyond that and covering the entire. So that's and beyond that, what is also happening very critically is, of course, the fact that UAPA, building from that legacy, how it takes off and where we are today. So while there are continuing legacies of preventive detention, there are continuing legacy of targeting of minorities and other groups, marginal groups, but then there's a very critical difference from what is happening in the last 5 to 6 years, especially post-2019 amendment of UAPA and what's happening, on which I'm sure other colleagues are going to talk about more. And therefore, in that context, how certain specific agencies on behalf of central government are getting weaponized. And I think that is very important, because that's also a watershed in some senses. It's not that it has not happened earlier. I talked about MISA earlier. MISA was, in 1975, it enacted a Maintenance of Internal Security Act, enacted during 1971 in the Indo-Pakistan war context. But it was during the emergency, 1975 to 1977, when Indira Gandhi regime brought MISA to actually, under various amendments, to actually deploy it against all kinds of political oppositions. Some 100,000 people were actually arrested, which included journalists, scholars, activists, opposition politicians, without a trial for a period of up to 18 months. So you have this legacy of actually crushing down political opposition of any kind. And now you see, of course, building on that. Now in 1984-85, you see a series of, once again, in the wake of, ostensibly in the wake of disturbances in Punjab and so on, what you have, this Terrorist and Disruptive Activities Prevention Act of 1985, TADA, which was once again, targeting to so-called terrorist acts, or those who conspire, attempt to commit, advocate, abet, advise, or incite, or knowingly facilitate the commission of a terrorist act, and so on and so forth. So you have this entire very stringent draconian law coming in. But what is interesting is that while, of course, it was used to massively deploy arbitrary arrest, detention, extortion, torture, extrajudicial killings, thousands of disappearances, which till today continue to reverberate, especially in the state of Punjab and beyond. But what is also interesting is actually that even during the heyday of TADA, many more arrests actually happened in Gujarat, and practically most of them of Muslims, than actually even of Sikhs, who were another religious minorities and so on. That's a very interesting data which you'll see happening. At the same time, what is very interesting is that, TADA data also shows officially once again that when it was in operation in 90s, it shows that only just about 8.81%, 0.81% of the 52,000 or over 52,000 individuals detained had actually been convicted. In Punjab, the conviction rate was even lower, just 0.37%, and so on. So you have this continuing legacy of basically detention as form of punishment rather than prosecution and conviction of actually people who are being arrested under these acts. So that's you have a very strong continuing legacy once again there. As I mentioned earlier, out of 67,500 individuals detained under TADA till 1994, some 20,000 roughly were in Gujarat alone, which is not even so-called a terrorism hotspot and so on in any way, and so on and so forth. And who were these? Most of them were actually Muslim minorities and so on. Now you have a legacy of POTA, Prevention of Terrorist Activity Act, which comes in a little later after a huge hue and cry, public outcry, human rights judicial intervention, so on. Repeal of TADA takes place, and then you have a historical context of course, some terror acts of parliament attack and so on, and Prevention of Terrorist Activity Act happens in 2002. Now, once again, you have very interesting data coming. While it is used once again for 2 years of its life, when it was actually active, it was used once again, massively deployed against targeting of certain minorities. What is interesting is that, on the eve of POTA's statutes of repeal in August 2004 in Delhi alone, out of only convictions had been obtained only in 5 POTA cases, 4 in Delhi and 1 in Jharkhand. So you have this kind of a scenario. As of August 2004, 172 individuals charged under POTA were in jail, while only 17 had been released, and so on. Now, this is where you have this continuity of across the country. You have people being arrested in Maharashtra, in Andhra Pradesh, in Uttar Pradesh, and Delhi, and so on, and very few of them being released on bail and so on. All of them languishing inside under. So you have this legacy once again coming in. By March 2004, over 280 individuals had been charged under POTA in Gujarat, and all but one of whom were Muslim. So you have once again a continuing, as I mentioned this. Now, it was not just that, but the other interesting aspect is that also that of actually them being, especially in states like Jharkhand, Andhra Pradesh, and so on, this was widely being used, and which, of course, we know through other laws as well, sedition laws, National Security Act, which are some of the other acts which have been in operation across country. They have been used widely against Dalits and Adivasis in states like Jharkhand, Andhra Pradesh, and so on, which I mentioned earlier. Now, you have as bizarre a case in POTA. I came across one thing while just looking some notes for this talk, that where it was deployed against one 17-year-old young woman in Jharkhand who was simply charged and arrested under POTA because she was apparently challenging the entire patriarchal norms of her village society and so on, and because of which she was taken to court and charged under POTA and so on. Now, so 2 or 3 things very clearly what you see is happening in this legacy is that each of the terror charges, whether in the name of trying to save specific regions of the country, or actually trying to look at the entire country as part of that in the name of internal disturbances, you are targeting very specific sets of population, and that is very consistent. You're not just targeting, actually you are targeting specific sets of population, and you are also, the data also consistently tells you that hardly any conviction takes place and so on, because there is very little. So these are the 2 very now the third element which is very important to recognize for us now is that UAPA and the current context, which has changed the game to another level, where UAPA itself has a remit which very strongly central government's remit, and it shows increasing centralization of authority. It's not that other state governments are not utilizing it, but now UAPA, unlike other in which National Investigative Agency, which has been especially once again mandated legally to look at the terror charges, has been actually given a remit which bypasses all federal laws and federal powers in terms of bypassing state government's powers and so on. Unlike other central agencies like CBI and so on, you have NIA, which shows even more strengthening of the centralization of authority in that sense, insofar as anti-terror powers, legal powers are concerned, and in which persecution of whether it's a human rights activist or the minorities is taking place. The second thing which is very clear what is happening is that while the anti-national slogan was always a foreign conspiracy, anti-national thing was always there, what is being very clearly now done is that there's a sheer conflation between what we perceive as so-called anti-Hindu grievances, whether it's a cow slaughter, love jihad, you name them, all of that. And there are obviously several laws being brought in by ruling party across states where they are ruling actually, BJP in many of these states. But those kinds of agendas are being overlapped and conflated with what is called concerns of national security. So many of these arrests, many of these actually persecutions are happening, seemingly targeting not just Muslim minorities or or Christian minorities. Actually, I didn't talk much about them, but they are also, of course. But many of them are being charged under UAPA for so-called hurting Hindu sentiments, so-called endangering Hindu interests. And there is that conflation, which is a very, very, it's, as I mentioned earlier, it's not that law was not heavily prejudiced against minorities not earlier. They were, and the conviction and the arrests show that very well across the legacy. What is happening is that legally many of these laws are actually being deployed in the name. And I think that is a very, very critical difference and huge matter of concern. I'll stop here and leave it to other colleagues to actually build on that. Thank you so much.
Thank you, Avinash, for highlighting really the trends that have existed previously and putting the UAPA then into context of several other laws with very interesting abbreviations like TADA and POTA. Thank you for that. We're going to go a little bit more into depth on one case study with Bablu, I believe. I'd like to introduce then Bablu to us. Bablu is joining us from Manipur in northeastern India. So he's another hour ahead in time. It's very late where he is. So very grateful for that. And Bablu is the director of Human Rights Alert. He's also an Ashoka Life Fellow and was a Fulbright Scholar. And he's been fighting to really protect human rights in a conflict zone, the northeast of India, for decades now. So we'd be interested, Bablu, in how the UAPA is used in Manipur as a concrete example, and if that ties into anything that Avinash has already said about the targeting of people who are exercising their democratic rights and so on and so forth. And what I'll do in between is I'll interject if you cross 7-8 minutes, but I'll try to do that in a friendly manner because this is your space. This is your space to talk and share. So go ahead, Bablu.
Thank you very much, Elena. Kindly give me a signal by the time it's 8 minutes. And again, thank you so much to the London Story for giving us this opportunity to address the heart of democracy in some way, people in the European Parliament as well as in the various units of the European Union and the Commission. Well, I would again just to build on what Avinash had put. He has put up a wide kind of a wide angle to the whole problem. I would like to bring in specific focus to the way it operates in Manipur. Manipur is a small state of about 3 million people tucked in the easternmost corner of India, bordering Myanmar. And arguably, this is the state which is hardest hit by the Unlawful Activities Prevention Act, 1967. If you look at India's population of 1.4 billion, we are not even 1% of the whole country. We are just 0.2% of the population. But I mean, the amount of people who are detained under the Unlawful Activities Prevention Act we were at some point 65% of the entire country, a population of 0.4%, taking a share of burden of 65% of the detainee is extremely, extremely heavy. And at this point in time, I'm talking about 5 years ago, but at this point of time, we are second in terms of absolute number, just next to Jammu and Kashmir. But if you divide it in terms of the population, we are still by far the highest number of per capita people under the Unlawful Activities Prevention and people detained under the Unlawful Activities Prevention Act. So it has been very heavy to us. And to understand why so much of this application is heavy in this part of the country, we might have to look up a little bit in terms of the details of, for example, out of the 42 organizations which are proscribed as terrorist or unlawful organization, Manipur, again constituting 0.2%, has 6 organizations declared as unlawful or terrorist organization. And the reason for it, when it was notified as unlawful organization, is because they are trying to secede from India, and also if you look at it from the other point of view, from the history, they say they are trying to restore the sovereignty which was lost in a way that is illegal from the point of view of the Manipuris. I mean, this obviously requires us to spend 30 seconds on the history of Manipur, which stood as a kingdom in the pre-colonial, as colonial, as well as during the colonial era, as a sovereign kingdom. But it merged with the dominion of India under controversial circumstances only on 15th of October, 1949. And by that time of that merger, Manipur actually had its own constitution and a democratically elected assembly, perhaps the first universal adult franchise election in South and Southeast Asia under the Manipur Constitution Act in 1947. And there are still many people who are not happy with the way in which it was forced to merge with the dominion of India at that point of time. And people still think that the self-determination question of our people have not been addressed as yet. And all these 6 organizations which are banned under the Unlawful Activities Prevention Act, and all these people who are detained under the Unlawful Activities Prevention Act are in some way connected to this historical trauma, which has not been very well addressed. And we all know India have signed the International Covenant on Civil and Political Rights with a reservation on, of course, Article 1, the right to self-determination. But we need to dig a little deeper on what were the discourses which took place within the framework of the International Covenant. When India's periodic review in the second periodic review took place, the issue of this self-determination came up quite prominently. And there one, Mr. Bertil Wanegren from Sweden put a question to the government of India, and I'm quoting it from his own words that is recorded. India has ever since its independence has accepted the adherence of self-determination and said is coexistent with the principle of sovereign equality. I would take an example. According to the Constitution, the Parliament may by law admit a new state when there you recognize the self-determination of the people and a nation and a state to ask for admission into the Union. So far you recognize self-determination. But when the admission has been granted, then the people in the nation, when they will be consumed by the people of India, and those people do not exist any longer, and then self-determination of those people do not exist any longer, legally speaking, I mean. And then, because if the people of that nation wants to depart, want to leave the Union, I cannot see any possibility of doing so. And this was, then he went on to ask what would be the constitutional and legal processes that needs to be followed when these people actually want to get out of the Union. And this is where the Constitution of India is totally silent. And this is where Unlawful Activities Prevention Act now defines secession or the demand for secession or aspiration of secession as part of the definition of terrorism. And this creates a very complicated situation in areas where some of these questions have not been resolved. And in a way, Manipur is a classic example where these things are being played out quite, in a very difficult, when you conflate a political question with the counter-terrorism issue, then it creates a very complicated situation where a large number of people are detained because of this political condition. In the second review of the third review of the International Covenant on Civil and Political Rights, when the Human Rights Committee discussed all these issues very threadbare, it again gave a recommendation to the government of India, and it said, bearing in mind provisions of Article 1, 19, and 25 of the Covenant, the problems in areas affected by terrorism and armed insurgency are essentially political in character, and that the approach of resolving such problem also essentially be political, and emphasize that terrorism should be fought by means that is compatible to the covenant. And I think these are very, very strong reminders of how, unfortunately, in the name of fighting terrorism and secession, if you become a bigger terrorizing factor to the population, then population is sandwiched between perhaps a terrorist act of armed violence or for whatever political reason it may be, and the counter-terrorism measure, which is unleashing even a greater fear and going beyond the brief of rule of law or the requirement of the covenant, like the International Covenant on Civil and Political Rights, then it creates a very, very difficult situation for the population who are sandwiched. And to fight a fear, if you put more fear on the people, then people are squeezed in between this. When the UN Special Rapporteur on Human Rights Defender met the first ever visit into this region in 2001, in her report, this was Margaret Sakagia in 2011, when she came to Assam and met with some of the human rights defenders from Manipur, she again wrote in her official report submitted to the Human Rights Council and to the General Assembly that at the time of the visit, Manipur was reportedly the state worst affected by militarization, with more than half a dozen human rights groups having been banned as terrorists due to their human rights advocacy.
Thank you, Bablu. This is a very good example as well, given that recently India was commended for its counterterrorism strategy at the Security Council. Please do share all these links with me later on, and then I'll pass them on to the rest who are attending here, so that we have these quotes and the facts and the statistics. And do also check out the work by Bablu's organization, Human Rights Alert, which goes much more into depth on this. So thank you so much, Bablu. You have highlighted quite a bit how democratic dissent is therefore criminalized. And this is a trend that is extremely pertinent in Manipur, as well as across the country, and increasingly against student protesters, scholars, and academics. So for that, I'd like to welcome Lara Jasani. And Lara is an independent advocate at the Bombay High Court. She takes up cases of human rights violations, in particular supporting human rights defenders and environmental defenders. She's also active in the People's Union for Civil Liberties. And Lara, I'd like to invite you to share some of the cases that you think people should know about when it comes to the UAPA. And again, I'll rudely interrupt you at some point, but please do make sure that we've mentioned all the sources, and then I can circulate them afterwards for an in-depth reading. Thank you.
Thank you so much, Elena. And I also thank TLS for inviting us to this important meeting. I would, first, like to support what, the previous speakers have said, that the UAPA has been used as a tool to curb dissent of any form. And I would like to also emphasize that it is not just the misuse of the law, but the very purpose of the law, purpose for which this law was brought in such a draconian fashion. Although the UAPA is said to be an act to provide for originally was supposed to provide for prevention of certain unlawful activities, the ambit of the act was broadened to make it an anti-terror legislation. And in 2018, special provisions were brought into this act for prevention and dealing with terrorist activities. This also included, making some important, changes to procedural provisions. In particular, the bail provision was made draconian under Section 43D5, where it was required, there was a restriction provided to the court from granting bail if it believed that a prima facie case was proven from the documents that were submitted by the prosecution. This is an extremely restrictive provision because of which those who are incarcerated under UAPA and are denied bail. And we see this, happening across cases. A second, important, very draconian provision again in the UAPA is that it also has punishment for conspiracy to commit a terror act, which, where there is actually no incident involved, like where there has been no terror incident, where there has been no violence, the people can still be prosecuted under the UAPA, and they again, suffer incarceration for long periods of time. In 2019, in fact, an amendment was brought in which would, show individuals who are arrested, not just organizations that are banned under the UAPA, but individuals also can be declared as terrorists. So these some of the provisions I wanted to highlight from a legal standpoint that have been working against the human rights defenders who have been targeted using the UAPA. Now, of course, civil society in India has been demanding for a complete repeal of UAPA on the basis that these provisions are unconstitutional and they deny liberty, they deny the fundamental rights of those who are, being targeted using this law. I want to, in particular, talk about two cases. One is the Bhima Koregaon conspiracy case. I'm sure many will be familiar with this case. But the genesis of this case was took place on 1st January 2018, which is the Bhima Koregaon Commemoration Day. And in order to celebrate this day, several Dalit visitors were visiting Bhima Koregaon. Prior to that, on 31st December 2017. There was a meeting which was called in Pune, known as the Elgar Parishad. And several, cultural activists and others, were part of this. There were more than, there were hundreds of organizations that were involved in its planning. Using this, and of course, on the 1st January 2018, at the commemoration event, violence erupted. Because of insightful speeches and by Sambhaji Bhide and Milind Ekbote, who are two leaders from Maharashtra, and who incited youth to go and indulge in rioting. And an FIR was filed against them. That is, a criminal case was filed against them. However, in order to divert attention from these criminal cases, and in fact, there was no prosecution in these criminal cases that took place. Eventually, Sambhaji Bhide's name has even been dropped earlier this year from the case. The entire focus of the case was shifted, and human rights defenders were raided in April 2018. And a larger conspiracy case known as the Bhima Koregaon conspiracy case came into being, with counter FIRs filed against these human rights defenders. Now, many of these human rights defenders, including, Father Stan Swami or Anand Teltunde, were not even present at Elgar Parishad or at Bhima Koregaon, but they were still brought into this case. And arrests were made. Now, even before the arrests were made, there was a huge amount of vilification that took place by way of a media trial. And the police made public certain documents, which were later on found to be tampered documents. Now, there are 16 activists who were arrested in this case, of which Father Stan Swami, died in custody because he was not provided medical attention at the time of COVID. his death took place in July 2021. He was suffering from severe Parkinson's, but due to negligence of the jail authorities, eventually, he succumbed in hospital. And there has been a fatality that took place, of a very well-known, Adivasi rights defender in our country. Apart from that, there are today 3 of the defenders who are on bail. One is, Professor Varavara Rao. He was granted medical bail in 2021, which has been confirmed by the Supreme Court earlier this year. Anand Teltumde, who has just received bail on merit on November 18th, which is confirmed by the Supreme Court on November 25th. And in fact, I would like to read out a paragraph from the bail order, which says, in view of the above discussions and findings, we are of the prima facie opinion that on the basis of material placed before us by NIA, which has been looked into by us, it cannot be concluded that appellant has indulged into a terrorist act. The material placed on record prima facie does not inspire confidence to bring the appellant's act as alleged for the punishment prescribed under sections 16, 18, and 20 of the UAPA as they read. Professor Anand Teltumde was in prison for more than 2 years in this case, and this is the bail order, which says that after appreciating all the evidence in the matter, in fact, no prima facie case has been found. I would like to mention one more very important aspect. Of course, the third person who has also been released on bail is Sudha Bharadwaj, who received bail who's a lawyer who was also named in this case, and she received default bail on 1st December 2021. One important aspect that I would like to point out is that Arsenal came up with a report showing that the documents which had been relied by the police were actually planted in the devices of the accused, and there was a tampering of the electronic devices. In fact, those cases are also pending in the Bombay High Court. So we can imagine the manner in which there is fabrication of evidence, there is the denial of bail, there has been there has been a complete distraction from the actual case of violence that had taken place, which was against Dalit, visitors to that event by extremist, factions. And in spite of that, the entire case was, turned against human rights defenders. The second case that I would like to talk about very briefly, because I understand we're running out of time, is the Delhi riot conspiracy case from 2020. We all know that there was violence in Delhi, which happened in February 2020. This was also incited by Kapil Mishra and Anurag Thakur, who are 2 leaders from the ruling party. And Anurag Thakur, in fact, is a sports minister who incited speeches to commit violence. This was one of the reasons why the riots took place. There were FIRs filed against them. Instead, those complaints were buried, and a larger Delhi riot conspiracy case came into being, where 18 activists were arrested, 16 of them being Muslims, the community that was targeted during the riot. On 23rd June 2020, Safura Zargar was granted bail on humanitarian grounds because she was pregnant. On 23rd October 2020, Mohammad Faizan Khan, who was a SIM card seller, his only thing was it was a SIM card seller, and the police was relying on a WhatsApp group, WhatsApp chat. The SIM card seller was granted bail. And in June 2021, the Delhi High Court granted bail to Natasha Narwal, Devangana Kalita, and Asif Iqbal Tanha. So 5 accused were granted bail in this case so far. However, very recently in October 2022, Umar Khalid and Asar Khan were denied bail. I would just like to read one paragraph again from the Delhi High Court order, because it's very important to note that it has been the Supreme Court, it has been the courts who have even given these minimum reliefs, but even their hands have been tied because of the draconian provisions of UAPA. We are constrained to express that it seems that in its anxiety to suppress dissent in the mind of the state, the line between the constitutionally guaranteed right to protest and terrorist activity seems to be getting somewhat blurred. If this mindset gains traction, it would be a sad day for democracy. This is what the High Court said while holding that there was no prima facie case against Asif Tanha, Devangana Kalita, and Natasha Narwal. I'd like to end with that. We can, of course, discuss in the question and answer session. Thank you.
That's very powerful. Thank you so much, Lara, for also citing what the High Court itself has said and emphasizing that people do receive bail, but they receive bail after years in prison for despite absolute lack of evidence. And even if there is evidence, it has been planted in the past. That is indeed quite a hounding fact. And thank you for sharing those direct quotes from the courts with us. Now, finally with us is Dr. V. Suresh, and he is also with the People's Union for Civil Liberties, and he is the National General Secretary of the Union. He is a human rights lawyer and as such conducts extensive investigations into human rights violations. Now, recently, the union, the PUCL, published the first extensive report on the UAPA. So that is something we'll be sharing as well as a resource later on. But perhaps, Dr. Suresh, you can share with us now what the main findings of the report are. And then afterwards, we can take some of the questions that I see are already in the chat / the Q&A about the UAPA. Thank you. Go ahead.
Thanks, Alina, and the TLS for organizing this meeting at this particular juncture so soon after the UNHRC UPR hearings. My three friends have spoken extensively of three different facets of how the UAPA has been abused. Avinash in particular talked about the legacy issue of the UAPA. Very briefly touching about it, we have a 35-year long history of anti-terror law, which preceded the UAPA. There's one thing common in all the three laws that have existed, the main laws, which is the Terrorist and Disruptive Areas Act, TADA, the Prevention of Terrorism Act, which was the second act, and now the UAPA. The common point in all the three was the fact of thousands of people being arrested, most of whom were arrested on mere charges of conspiracy, with no real terrorist action having been committed. Now, the anti-terror laws are very draconian not because that they are providing for certain punishments, but for the procedural safeguards that they have dismantled. For example, on the whole issue of remand, when you're arrested and taken to jail, and how long are you kept in jail before the charge sheet is filed? Second is at the stage of the bail, how it's now almost impossible to get bail. Three is the length and duration of the trial, where during the trial, all procedural safeguards have been removed. The rule of law procedures don't exist. For example, the whole issue of identification of witnesses, no witness name needs to be given. Witness need not be shown to the accused. So in effect, the accused are fighting a battle with both hands, legs, and eyes tied. You can imagine what it would be like if you're charged against that, especially when almost 70 to 80% of the cases do not actually involve terrorist offenses. Now, this is an extremely important issue that we need to understand, partly because of the fact that all the procedural safeguards were dismantled on the whole issue that there is terrorism, and because of terrorism and threat to the Indian state and national integrity and sovereignty, we need to therefore have special laws doing away with the procedural safeguards and the rule of law safeguards. So the precise legitimacy was on the basis of terrorism. And therefore, the test of the law would be in terms of saying, how exactly has it been used? Because these are special laws for special circumstances and not to be used as a general rule. The legacy part of the thing across the, say, 40 years has been that it has been used against activists. It has been used against democracy workers. It's been used especially against minorities. It's been used against political opponents, and in some cases also against groups allegedly involved in violent attacks on the state. Now, this has been the common thing all across. So when, from my own personal experience as a lawyer fighting anti-terror cases over the last 30 years, and the experience of the PUCL, because we led the anti-TADA agitation, we were also very much part of the anti-POTA and now the repeal UAPA campaign. So we then decided that while we know personally from experience, that still was anecdotal. We needed to have figures to back up our claim of how rampantly this law is being abused. So there are a number of things that has been there in our report, which we have already shared with you, which you could kindly share it with others. Now, 3 or 4 of the key things alone I would like to highlight to demonstrate that from the data of the government itself, this law does not bear looking at. The data of the government of India itself and the National Crime Records Bureau itself shows the abysmal state by which this particular law has been abused, and how the law itself has been weaponized, and how democratic activities have become criminalized. I think this is something that we embarked upon a couple of months ago to say, let's now look at the data. Now, it's a two-phase study. We have finished one phase of the study, which is the data of the government of India. And the second phase, we are actually doing it with actual cases from the grassroots all across the country. I would like to point out to two things. One, the data, there is one issue that is important. When we talk about UAPA, we are only talking about extremely important, very politically charged cases like the Delhi cases or the Bhima Koregaon cases. In between them are thousands of ordinary people, Adivasis, Dalits, other people who are fighting for democracy, whose names don't come into the paper. And they constitute the maximum number of people in jail without bail. According to the government of India, between 2015 and 2020, there were 5,924 cases of UAPA, and there were 8,371 people arrested. This was a figure given in the parliament. Now, whether this figure is right or wrong is a big issue, but we'll go with the figure because this is a government figure. This is NC, National Crime Records Bureau figure, which was given in the parliament. Now, when we said, let's look at this figure in three indices, which will indicate how this law is used. Because if these indices do not bear scrutiny, it's a very important question as to why this law should be continued at all. One, we said, now let's look at bail. How many people get bail? Now, as previously stated by both Bablu, Avinash, and then Lara, bail is almost impossible to get, because the standard for getting bail, as was amended in 2009, was to say that if a person has been in jail for, and the charge sheet has been filed, if the prosecution is able to show through the police investigation papers that a prima facie case is made out on reasonable grounds, that is enough to deny bail. Now, most often, this is exactly the provision which was challenged even in Tada and Pota as saying, now what will constitute reasonable grounds is a very fuzzy type of a thing. Now, if you do not come across this, these grounds, then people will not be given bail. Now, a very common sense issue. You don't need to be a lawyer to understand that anybody arrested and put behind bars for 6 months or more is obviously going to have some paper alleging that he committed XYZ crime and he's in jail. And therefore, there will be a paper, there will be some paperwork and some documentation. Now, the Supreme Court of India, unfortunately, in a case called the Vatali case, said that's enough. You can't go more into it. You can't go into the number of witnesses, how long has it been going on, whether the person who has applied for bail was actually a key accused, or he was just somebody who gave tea, or he was a tailor giving uniforms to somebody or not. So those were the things we had to look at. The figures are shocking. Government figures between 2018, 19, and 20 shows a maximum of 16.5 to 17% people who got bail. Now, according to human rights activists, this 17% itself is too high. But we will just go by the government statistics. In 2019, they padded up the figure. If you remove the padding up, it comes back to 16.5. So even if we say 17%, 83% of people arrested under UAPA, that is 8,371 people, and this stops only in 2020, do not get bail at all. They spend 3, 5, 7, 8, 10 years in jail without getting bail. Okay, this itself is one very immediate issue that should be flagged, that under the procedure, it's been twisted in such a way you can't get bail. Okay, and this is through the process of law, which is why we are saying law itself has been weaponized. Second, we looked at conviction rates. What is the conviction rate of people arrested under TADA? It comes down to 2.8% of people who have been arrested under TADA and who have not got bail. Now, this is an extremely low figure, but there is a continuity with the past. Even under TADA, it was less than 3. Even under POTA, it was less than 3. And under UAPA, it's less than 3. Which means 97% of people who are arrested spend time in jail, 3, 5, 7, 8, 10 years in jail. There are cases where 18, 19 years after they were arrested, people have been let out on, have been acquitted. They then get acquitted without case. Now, the issue is 98% of the people, of 8,371 people, are acquitted at the end of long period of trial. The point to be noted, it's not just the individuals in jail, it's their families, it's the communities, and the larger trauma that the community will suffer. Okay, this is the second point that I think that the international community needs to keep in mind, which is 8,136 people out of 8,371 people arrested under TADA. Again, between 2015 to 2020, it's 2 years since this last data came. We do not know how many hundreds have been arrested during this time. Came out on, would have been acquitted. Now, what reparation do you pay for them? Not just to the individuals, the families. There are cases which I should just very briefly talk about, where after 5 years in jail, we have done nothing. They don't want to go and bang their heads against the state to get reparation or compensation. It's scary because you will be thrown inside again in another set of trumped up cases. The last part, it's a point that Lara had talked about, is that then we said, okay, if they are going under conspiracy, where the only charge is that they conspired to do something, you don't need to do an actual action. Just the conspiracy that two people came together or some set of people came together, they decided to do a terrorist crime. That's enough. Now, we would think, one would commonsensically think, somebody has done some terrorist act. There must be some terror, some bomb burst, some weapon, somebody killed. No, the reality is that 64% of the cases charged under conspiracy did not have any specific incident, which constituted, say, 43% of all the UAPA cases filed under the NIA. Now, this is again one dimension to show how this law is abused. I will just now quote three cases of how NIA courts, after 5 to 10 years, acquitted people. There's a case of a Kashmiri who had gone to Gujarat to do post-cancer care, to take post-cancer care. He was caught up in a trumped-up UAPA case and thrown inside jail. He spent 11 years and 3 months in jail. He was acquitted with the NIA court. Now, see, this is important. A trial court is the one which sees the evidence, which sees the policeman, which sees the witnesses, and which sees the accused. The NIA court says the prosecution relied on emotional arguments, and a person cannot be held guilty merely on the fear of anarchy. This is not me saying. This is the court saying, the trial court. Okay. Now he spent 11 years and 3 months. It is not just Muslims. It is also Adivasis and tribal people. 121 tribals were arrested in 2017 in a Chhattisgarh case. 5 years and 3 months after they spent in jail, they were acquitted. And the court said, the NIA court said, no charge is found to be substantiated in the offense charge against these accused. Finally, I'm just saying, this is across the state, not just in the very famous politically charged cases. The last case is of a person from Tripura, a northeast corner state, who went to Bangalore in South India as an auto driver. He was caught up in a case, in a UAPA case, and thrown inside jail. He spent over 4 years in jail. He was discharged by the UAPA court, and the NIA judge said, I fail to understand why this accused was arrested in the first place at all, and why he was needed to be charged. Now, what is the government of India and what is the legal system in India going to do about reparation for such people? The point I would like to leave is, we will be making a mistake if we only look at the number of people arrested. Thousands of people in all these cases, human rights activists, academics, researchers, lawyers, doctors, are called in for questioning. And everybody has this fear. If I am implicated and thrown in the UAPA, I have to now forget 5 to 8 years of my life. Okay. Now, in the Bhima Koregaon case, we know 400 to 500 people were called. We know in Delhi, well-known political party leaders were called. After that, they go silent. Now, this part of the picture is not coming out at all. We only see the ones arrested because they have to show them in some figure or not. What about the people who are called in for questioning and random questioning? This system of fear has enveloped the country. And this is the basic threat of a UAPA, which is that it not just undermines, but it destroys a very democratic fiber, which is why we all say no tinkering with this law, no dilution of this law. This law has to go wholesome, lock, stock, and barrel. Thank you.
Thank you, Suresh. And I suppose then we're also a bit grateful for Belgium's recommendation during the UPR on November 10, in which Belgium very strongly said India should repeal the UAPA. And other countries at least said, let's revise it. But as you have highlighted, the existence of this law and the lack of procedural safeguards and the absolute ignorance of the rule of law in this case mean that the law has to go and cannot come back in any other form. We have time for about one question. These were just such good interventions that I did a terrible job at moderating and cutting you all off. I hope that that will be forgiven just because of the quality of the interventions made. So I would like to invite then the people who already have their cameras, the potential to turn their cameras on, to please simply let me know if you have a question. Otherwise, I will take one from the Q&A.
Alina, if it's of anything from our side, at least a few of us, we are okay to spending more time if there are questions. Because this is too important a matter for our democracy to stop a couple of minutes. I'm sorry, I'm interjecting into your time.
One of the attendees would like to know then a bit more about the Supreme Court's position. Given that there is now a new Supreme Court of India as well, a new Supreme Justice of India in the Supreme Court, who many people put a lot of faith in. If the Supreme Court has taken action, one of the interventions here today has said, no, it has not really taken action and has said that the lack of evidence is okay. But is there any hope that the Supreme Court will take this up? Are there any petitions planned? Is there any way, if there are petitions planned, for the international community to support them in any way?
Anybody else going? Lara? Avinash or Bablu? Okay, since I seem to have the space here, I would just like to briefly say much depends upon the nature of the judges and the benches before which UAPA cases go. Amnesty India and POCL came out with a report some years back on death penalty. We called it lethal lottery. And there's a former Chief Justice of India, Justice Bhagwati, who said, ultimately much depends on the social and the political perspective of the judge before whom a case comes. So in a very short way, Alina, to answer the question from the panel, from somebody in the audience, much depends upon the social and the political philosophy of the judges. Yes, there is a slight opening of the window and a musty room. There's some air going in. We hope it will be there and a little bit of the cobweb will be taken away. But that's what it is. As much as Professor Anand Teltumde's appeal against his bail was dismissed at the very threshold, there was another case of Professor Sai Baba, who the Bombay High Court, who was convicted under UAPA to life sentence. He's 95% paraplegic. All that can move is only his head and his eyes and his face. Below that, he's completely immobilized. He spent over 4 years in jail, mostly in solitary confinement, in absolutely horrible condition. The Bombay High Court, at the end of a criminal appeal, discharged him and the other co-accused, the co-convicts, not accused, they were convicted. They discharged them. On the same day of the discharge, the NIA, the Government of India, moved an appeal before the Supreme Court. The present Chief Justice, who was then the second judge, refused to entertain that case and refused to give an appeal to stay the acquittal, saying a discharge is in the nature of an acquittal and you can't stay an acquittal. And this is from an appellate court. But however, the next day, it was brought up before another bench and on a holiday, a weekend, Saturday, it was a special bench. That bench stayed the operation of the order, and Professor Sai Baba and others are in jail. Okay, there are many other things that have been happening. The Bombay High Court ruling giving bail to Professor Anand Teltumde, which has been upheld by the Supreme Court, gives us a little hope that perhaps slight changes coming up, also because of the campaign and the voices from not just India, but throughout the world.
That's very lovely that there's a little bit of hope then. One other question that I'm seeing in the Q&A is about the elections that are upcoming. Now, there are some state elections, but there's also then of course, Indian general elections in 2024, coinciding with those in the EU and the US and I believe 70 other countries in the world. Is there reason to think that things will get better to such extent that the UAPA may be indeed repealed? Or are we expecting the upcoming elections to rather serve to crack down further on civil society? Avinash, maybe you want to take this one?
Sorry, just a sec. I was just looking at the question and I lost track of which question you wanted me to answer. If you can just tell me. I mean, I see two questions in front of me, but yeah, just quickly, the first one for the opposition, UAPA being used against opposition parties. Is that the one you wanted me to, or?
I'm kind of mixing both of them a little bit because I'm seeing a trend in wanting to know about the future, prognoses for the future and what's to come, especially in light of the elections and whether that will be scope for parties and the courts to say, let's repeal this act, or whether it will lead to more crackdown on increasingly more populations, including opposition and minorities.
So I think what I think Suresh was earlier trying to say by reference of some one of the things which he mentioned, I think if I heard him correctly, was the fact that a lot of times repeal of such acts during such extraordinary circumstances also means that one, of course, there's a massive political change, which as of now, and as happened in the case of 1975-77 emergency and post-emergency, the opposition came to power and of course visa was repealed and a lot of work happened. Now, I don't know whether that is at the moment a real possibility in the immediate future or not. But what is certainly possible is two things. And one is that how do you create a wider ecology of actually pressure against any such laws on Indian government, and which means therefore not just Indian national, the country, the population living within the country, inside the country, but also outside. And a couple of questions are asking that question as well. It's important that while current regime is actually internationally trying to champion itself as a champion for democracy and telling the other warring countries that it is not the time for war, and then you are waging war against your own citizens. Actually, is this duplicity, this actually hypocrisy needs to be called out by those champions in democracy sitting in the West who are also engaging with Indian government on a whole range of other issues, including commerce, etc., etc. Now, how do you do that is a question. One, back channels, certainly, but more importantly, I think if there's a larger ecology which is created in terms of continuous public verbal pressure through multiple forums, at least some of that work would have been done. Of course, there's no guarantee that that will lead to repeal of such laws or not, because as Suresh and all of us were talking about, there's a history of such laws for the last 40-50 years. But there's also a history of repeal of such laws. TADA was repealed, POTA was repealed, and so on and so forth. So there's also a history of repeal of such laws. Of course, UAPA has come since then, and it has been further made obnoxious, actually abhorrent, and so on. But the point is exactly that even if we don't see much immediate, because it's difficult to be, an astrologer in terms of saying that, okay, the political regime will change in 2 years from now and things will happen and they may change. That's not the point. Point is, how do you continue creating a larger climate in favor of repeal of such laws, and for which all the pressures from within and outside and consistent pressure, I believe, is the only answer. Yeah.
Thank you so much. Then what I'd be curious about is the support that can be given to you as human rights defenders. As Suresh highlighted, you are very much under threat to be called in for questioning, as 300 people have already been. And this can then lead to very, very dire consequences for the state of human rights in India. Is there anything that we hear from Brussels, from Berlin, from wherever we're joining this call, can do to support you as human rights defenders in your work beyond just sitting in this meeting with you?
Well, yeah, I think what you are doing now is, I think, a very important intervention. That voices which are there needs to be amplified, and it should reach the right places where it matters, where there is a consistent effort to for the promotion and protection of human rights globally. I think it's very, very important. But it's also important when crises do fall on these people who are trying to, work at the grassroots, at the front lines. The support system around them and has to be strengthened. Of course, we cannot spell it out. I mean, in 30 seconds, what are those? But I think the solidarity and the listening that I think is taking here is as important. There is a need for also groups within India to empathize with each other and do a much more solidarity building across the regions, across ideological barriers, as well as I think it is now, as they say, when the going gets tougher, the tougher gets going. So it's a very tough time, but this is also an opportunity for building solidarity, because 10 years ago, it's only the pockets in the peripheries of the country which was suffering the very brutal nature of the state. But now today, this had spread across the country. On the one hand, the brutality is increasing, but this is also an opportunity for us to build solidarity across the differences and make this voices of democracy and human rights stronger. That would be my perspective, so to speak, on this issue.
Wonderful. We will then continue to do that. Suresh, would you like to make another point?
When the United Nations was first set up, it was supposed to be the forum for the people of the world to prevent authoritarian states from asserting their will. Unfortunately, the UN and similar other systems have become a club of the states, and geopolitics is what is determining human rights positions and not the fact of human rights values. So you have a G20, in the morning, the G20 members come together, there is an anti-China thing, and you want to build up a thing against China or against Russia. Those are predominating human rights concerns and not the reality of human rights in many of these countries. In India, we were particularly struck by the fact 2 months back, our Prime Minister went to Europe in the G20 meeting. In the morning, they talked about, waxed so eloquently about democracy in India. The same day, a Muslim fact checker was arrested and thrown in jail, for something that he had given 4 years, he had tweeted 4 years back. This irony, I think, is important, and it can be broken because it's a club of the countries of the world who, for geopolitical reasons, will wink their eye when they see this. So it leaves it now upon 3 sets of people. One would be civil society in India, with solidarity action with civil society groups outside India. 2 would be policy influencers in various places who should be able to talk irrespective of their institutional affiliations, and members of parliament in various other places who also have a larger responsibility than the narrow aspects of geopolitics and geoeconomics. So I think it is this type of a building that we need to build up, this type of a bridging that we need to build up, where Indians also talk about what happens in Burma or what happens in other places. Similarly, there are Europeans and others who talk about what happens in India. I think this is extremely important. 2024 elections, like Avinash was saying, in Tada, at the time, I was part of the campaign for the last 30 years. Nobody thought that Tada could be thrown out. Nobody thought that Pota would one day be repealed. It did happen. People got arrested for even saying that there should be a repeal UAPA, a repeal Tada and a repeal Pota campaign. So I'm very hopeful. We'll have to build it. It's not an easy job. It's something that's happening. And I would like to put on record here that in the last 1 year, we have had more political parties, mainstream parliamentary political parties, taking an open public stand, calling for nothing else but a repeal of UAPA. Okay, government of Kerala went to the Supreme Court 1 month back in a case where they had filed an appeal on a procedural safeguard in UAPA. They went back and said, no, we want to withdraw our appeal because this mandatory provision is very important. And we don't want to be party to the dilution of a mandatory standard. It's too difficult now. It's a technical issue. Just want to highlight the fact that the pressures from the ground, pressures from outside India and larger public opinion is actually having its impact. And I'm hopeful that we need to keep building on it in a consistent manner.
Fantastic.
I'd just like
That's
to add
hopeful.
one thing. I think, one of the things that, we need, apart from even the solidarity, that we are receiving today, I think, which is very, very important, like Bablu said, is for the repeal UAPA campaign to become a global campaign. Because what is also happening, with the targeting of the human rights defenders is vilification of human rights work itself. The chilling effect this is causing, the kind of, the kind of attack on credibility of human rights work and human rights activists is also going to affect the human rights standards in our country. And I think that should be a very important factor why everyone around the world should be invested in this campaign. So, just wanted to add this. I think what we need today is for all of you to join the campaign, to repeal UAPA and to try and demand it of the countries in various forums.
Wonderful. On that note, we do need to recall that the European Union, in its founding treaty, has the pledge to support democracy, rule of law, and human rights abroad in its foreign policy. And it's therefore not just us saying that the EU should support India, that it should support human rights elsewhere, but indeed, as you're saying, Lara, to remember that this is the very purpose of its own existence, the very thing it was founded to protect, and that a threat to human rights anywhere is a threat to human rights everywhere. Again, I will consolidate all the things that we've discussed here today in a little overview document, all the links, all the statistics, all the cases that you've mentioned, and I will send that over as soon as I can, including what people can do. And then I pledge that I will continue to push for action. And I hope that the others who are here today as well, from the Commission, from the EAS, from the Parliament, the Intergroup on Religious Freedoms, as well as AFET Committee, and so on and so forth, that they will also incorporate what they've heard and hopefully continue to be in touch with us on this. So I'm really grateful that you've spent your evenings, your nights in Manipur with us here today. And I wish you all a fantastic evening, but please do not forget what you've heard as you have dinner tonight. And please be in touch. Thank you so much.